Hello and welcome to another episode of BioTalk. I'm Chelsea Zimmerman, and with me today is Jim Cole. Jim Cole is actually a good friend of mine. We go back quite a bit. He's the general counsel for Missouri Right to Life, where when I lived in Missouri, I used to be on the board of directors of Missouri Right to Life and worked with Jim on quite a few things. And I actually still do quite a bit for Missouri Right to Life. I'm their social media director, and so it's good to get back in touch with Jim. But and thank you for being on here with me today.
Well, thank you, Chelsea. I look forward to it. It's a great opportunity to talk to people about these issues.
Right. So the reason I asked you to come on is that there is a legal brief being filed by a number of pro-life organizations, Missouri Right to Life being one of them, involves a battle over frozen embryos. This isn't something that the pro-life movement has really gotten into much, so I was kind of excited to see this happening. So why don't you give us a little bit of background on the actual battle, the battle over the embryos, the case, the first case that is involved in this.
All right. It came to Missouri Right to Life's attention because the mother of these children reached out for assistance after the trial was over. She and her husband had a very contested divorce, and one of the issues in the divorce was what to do with two frozen embryos that they had created earlier when they first got married. The mother's name is Jaleisha McQueen. The father is Mr. Gadberry, and they got married about 10 years ago, and at the time she was a veteran of the armed forces, and she was working as a lawyer in a law firm here in St. Louis. The father was still in the armed forces. He was in the U.S. Army, and he was facing deployment overseas, specifically to the Middle East. So Ms. McQueen, being a little bit older, wanted to preserve some way to have children with her husband if the worst should happen. So she asked him to leave specimens of frozen semen with a reproductive doctor here in St. Louis, which he did. He was called overseas, and while he was overseas, of course, he stayed in communication with his wife, Ms. McQueen. She tried to have children using insemination from the husband's frozen semen, and for some reason that didn't work. So they agreed that they would try in vitro fertilization, taking his semen, her eggs, and doing the fertilization inside scientific conditions outside of her body. So that's what ended up happening in 2007. They had 4 embryos that were created that way. 2 of them they implanted into Miss McQueen right away, and now they have 2 lovely boys that are about 8 years old, going on 9. But 2 of them they left frozen in with this doctor here in St. Louis. As things came to pass, the husband came back from the Middle East in fine shape. He was going to graduate school to get an MBA, I believe, and then their marriage started falling apart. So in 2010, they separated, and they kind of forgot about the embryos for a while, I guess, or they didn't pay much attention to the 2 that were still being stored. Sometime in 2010, the doctor that was storing them decided to retire. He had reached the age. He retired, and he wondered what to do with these, and I'm sure others that he collected in his time as a doctor. But for these 2 particular ones, he contacted them and said, what do you want me to do with them? They agreed to have them stored in a facility in Maryland that apparently is a big business on and does this as part of its business, storage of cryopreserved embryos. So they had the 2 shipped out there, but then as their marriage fell apart, they had divorce proceedings. Actually, they had two different cases that they started and then stopped and tried to reconcile. But it all didn't work. They had a third divorce, and this is where the case actually came up. They couldn't agree on what to do with the two frozen embryos. The husband wanted to destroy them. He didn't want anything to do with the wife. He doesn't want anything to do with any more children. And even custody arrangements for the two boys that were born were hard to arrange between them because there was so much animosity. And it's, it's not untypical of divorce situations. I did divorce law when I was first a lawyer 30 years ago, and these child custody cases are just the worst, and unfortunately this got to be one of them. So they finally went to trial in 2014 on their divorce. They had worked out parenting and visitation arrangements for the two born children, but they just couldn't decide and agreed between themselves on the two unborn, the ones that were still frozen. And that's what the trial was about. So they tried the case, but they didn't produce any scientific evidence, and very little evidence at all, really, about how the children were produced or what their status was. Their argument was over whether a contract that each of them signed was valid, and for various reasons the trial court felt that it was not valid. And so the trial court was left without much to go on except the fact that these two people were fighting over embryos that were frozen and in storage in Maryland. So the trial court ruled, based on previous cases from other states, that the two embryos were a kind of property, but it was special property, not just ordinary property. So the trial court ruled that the embryos would stay where they are so long as somebody paid for the storage costs, but they couldn't be implanted into anybody, including the mother who wanted them implanted so that she could bring them to birth. And they couldn't, and then she wouldn't, but she couldn't do that unless the father consented. And the trial court ruled in its final judgment that it took the consent of both the husband and the wife who were getting divorced before anything else could be done with the kids except keeping them in storage. So that's where the trial court left things, and it finally issued a judgment this year.
And go ahead.
I was just going to say, I've spent a lot of time talking about that. So
No, we need that. That background's good. I mean, this is and so after the what was the final judgment then? You said the
final judgment as to the two children who are still frozen as embryos was that if either party wanted to keep the storage arrangements and keep them from being destroyed right away, they could pay for the storage, and that's what Ms. McQueen has been doing. But they couldn't do anything else with them unless both parties agreed. The court was not going to force something down either one of their throats. The court was very concerned that if it allowed Ms. McQueen to have the embryos like she wanted, then it would be imposing additional child support costs on the husband. It would be, and the court would be imposing a duty to procreate on the husband, and there's really, the court said, a right not to procreate, and therefore it was going to require his consent to do anything else than leave the children in storage. And on the other side, they couldn't be destroyed without the mother's consent. So the court just left things hanging until both parties got tired enough of fighting to reach an agreement on what they should do.
Wow. So it would impose on the husband, even though procreation has already taken place.
Exactly. That's one of the arguments that we raised in the brief. Hey, it's too late for that argument. But the other cases from around the country have ruled that there is some kind of right not to procreate after this has happened, which is totally opposite of what the scientific facts are.
Right.
But that's what most of the states have been ruling these days.
So how and why did how did Missouri Right to Life and some of these other organizations get involved, and what are you guys doing to help her out then? Okay.
The mother, naturally enough, appealed the decision to the Missouri Court of Appeals. And as part of that, she asked for briefs of what are called friends of the court. Either side or both sides can ask interested organizations to file briefs if the court allows, in cases where there's some novel question or some issue that affects not only the parties, but also, something that affects society as a whole. And certainly the status of unborn human beings, frozen embryos in this case, affects society as a whole. Missouri has a law on it that should be applied, and the trial court refused to apply it. So Ms. McQueen reached out to Missouri Right to Life, and we in turn reached out to other organizations. So the brief that we filed with the consent of the court as friends of the court included Missouri Right to Life, the Lawyers for Life here in Missouri, and also the American Association of Pro-Life Obstetricians and Gynecologists, which is a nationwide organization of OB-GYNs who are pro-life.
Oh, good. That's a good group of pro-lifers there, and you helped edit the brief, from my understanding.
Yeah, it was a joint effort, and somebody kind of had to lead the team to put it all together and get it down on paper, and that was my job. And I was very happy to do it. The American Association of Pro-Life Obstetricians and Gynecologists was represented by the Thomas More Society, and you've heard of those folks. This is the Thomas More law firm that's in Chicago. They represented Joe Scheidler for so many years against Planned Parenthood when they were trying to shut him down, and Tom Brecha is their chief counsel. Tom is a brilliant lawyer, and they have a good law firm up there and a lot of good volunteer lawyers helping them in Chicago. So they provided, in fact, a lot of the scientific information that went into the brief, and I'm very grateful because they had up-to-date information that I was not aware of, particularly on fertilization. I think at my age, you can tell since I talked about practicing 30 years ago, I'm a little bit older than maybe a lot of people, a generation older than you are, Chelsea, and I learned my basic biology and facts that support the pro-life side in the 70s. Well, biology's advanced a little bit since then, and they managed to put together a very compelling set of facts and how to narrate those facts and doctors and scientists to quote from that was the scientific basis for this brief. I added what Missouri law provides in our statute that was passed in 1986 that says that the life of a human being, basically, it begins at fertilization, and that every person from that point on has legal rights that can be protected and should be protected by the law, and that every person from that point on, their parents have rights over, so that if there's a wrongful death or other injury, the parents have rights. And a third part of the statute said that interpretation of what a person is and legal rights will apply no matter what kind of law is being applied by the courts. So it's not just in the area of abortion, but also in all other areas. And Missouri law has had that provision in it since 1986, and the courts have been very consistent in enforcing it the way the legislature wanted it to be enforced. So we have cases that have come up involving homicides, both intentional and unintentional homicides of unborn children inside the mother's womb. And aside from abortion, those homicides can be prosecuted as crimes in Missouri because of that law. And then on the civil side, with wrongful death actions, for instance, where somebody causes a crash, causes the death of the child in the womb, parents can sue for damages to make up for those. So this law has been very powerful, and the trial court completely ignored it. Didn't say anything about it. Didn't acknowledge it at all, which is very surprising. So we jumped in. And my part of the brief was to outline Missouri law and then meld all these elements together into the argument that we finally put down on paper.
And what specifically is that argument? What does the brief specifically say then?
It's basically three parts with some subparts, but our main argument is, one, science says that a person exists from the moment of fertilization. And fertilization occurs not just when the DNA of the mother and the father emerge, which is how I learned it in high school and college, but even when the sperm first enters the egg, the oocyte, there's a melding of the membranes that surround each of the cells, and that melding of the membranes takes about 1 second. At that point, the membrane closes off so that no further penetration of the egg by a sperm can take place. But also, the egg is no longer just an egg. Mm-hmm. It acts like an independent organism from that point on. Mm-hmm. And that's a new part of science that I didn't know before. It's very, very fascinating. Mm-hmm. So we made that scientific argument at some length, quoting some of the top embryologists and biologists of the country. Mm-hmm. The second part of the argument was the argument on Missouri law. The legislature has already recognized, Your Honors, that human rights begin at fertilization. Mm-hmm. We don't know why the trial court refused to apply that, but we're asking you to apply it. Mm-hmm. And then the third part of the argument was to comment on two particular cases that are viewed as precedential in this area. One is the case from Tennessee. That was the very first case involving a custody fight over frozen embryos. Mm-hmm. And Dr. Lejeune from France testified at that trial. It was in Tennessee in the 1980s. Mm-hmm. And it's the only case that we know of where there was a contest over frozen embryos that the trial court actually took scientific evidence on, which is really astounding. And Dr. Lejeune, of course, was the world's foremost authority in all of this at the time. But the Tennessee Supreme Court said, he was prejudiced and we're not going to listen to him. We're going to listen to the other people who are in the industry. They know better than this outsider that came in from overseas. And the Tennessee Supreme Court is the one that started the idea that this frozen embryos are just property, special kind of property, granted, but still just property, and that they aren't really human beings. Well, we took that apart, basically, with the scientific knowledge that has accumulated since that decision was made in about 1990. Mm-hmm. And then we commented on an Iowa case that was more recent that the trial court here depended on. But it was not nearly as focused a case, and it was fairly easy to criticize. The trial court didn't follow it very well, even though it said it was. And then we added that we've had some experience in this country with defining biological human beings as being merely property, and that was with the Dred Scott decision back in 1857, and that didn't turn out so well. Maybe we ought to think about it again with regard to frozen embryos too.
Exactly.
Yeah, that's the essence of what our brief said to the court in much more legalese type of language, of course.
Right. Oh, well, that's very interesting. So this brief has been filed. Where does it go from here? Like, what's the process then after this?
On an appeal, each side has a chance to file its briefs, and the friends of the court that support a side file at the same time as that particular party. So the mother was the appellant. She had to file her brief first. And the brief is the written arguments that advise the court for an appellant where they think the trial court went wrong. And the whole point of the appeal is to see whether or not the trial court handled the trial correctly. So we filed ours in December. The other side had a month to file theirs, and they've asked for an extension of time. So we're waiting for the respondent, who's the husband, to file his brief and to see if there are any friends of the court that he's brought in, and I fully expect there to be. And that's due about February 20th or so.
Oh, okay. Nice. Well, I'm just, like I told you before, I was really happy to see Missouri Right to Life, especially, and some of these other pro-life organizations get involved in this because like I said, this is not something the pro-life movement has really gotten involved in. We're still fighting abortion. We're still euthanasia is very much something that, especially like with National Right to Life and some of the major organizations that they're involved in. But IVF and reproductive technology is not necessarily something they've been involved in, and and it's not necessarily something that the pro-life movement as a whole is in agreement on in terms of just generally speaking the ethics of it. some people think it's a good thing that we're creating life rather than destroying it. And but this is an area where I always kind of felt like even pro-lifers who were in favor of reproductive technologies like this could find common ground with those of us who don't necessarily support it in general. The legal aspect of it, and treating, just on paper, how the embryos are considered property and not people, and just how dehumanizing that is, so I was glad to see that the pro-life groups were getting involved in this, because and the way it's worded in some of these articles I've read about it is really what's the most important thing about reproductive technology is what's in the best interest of the children being created. What's in the best interest of the embryos. And that's not something that's always considered, even when the couples aren't disputing with each other. It's usually never about what's in the best interest of the child. It's what's in the best interest of each of the adults that are involved. And I we need to shift that focus where, you're creating people. These are people you're creating, and they, you need to consider what's best for them, not just what you want, not just what one party, one adult wants versus the other one. These are human beings we're talking about here. And these should be held in the same legal standard as child custody disputes, not property disputes, which is, it seems to me, how they usually are. I mean, I don't know about every case. This is obviously not the first or only time this kind of dispute has happened between a couple that has created these embryos. But I think most of the time it is a matter, they are being referred to more as property than as actual offspring.
I have to agree, and I think that part of the reason is people don't want to deal with the very sticky issues of what happens when there are disputes like this one, or even other questions like some of the embryos are destroyed right away because there are too many of them. And people just don't want to think about doing that and the implications of that when they're trying to have children. So if they get 6 embryos instead of the 2 they wanted, and 4 of them are destroyed and 2 are implanted, well, they basically just shove it down in the cellar of their mind and close the door and hope that they're never bothered by that.
Right.
And that is too bad. Very much a problem.
Exactly, and it's a legal problem, and it's the for all the ethical questions there are with this kind of technology, it's in the last couple of decades, it's created this kind of legal mess of what is the embryo? Is it a property? Is it a child? In some of the other cases that are related to this, I think when we mentioned, we were kind of going over this before. In related to that, there surrogacy is related to kind of these kind of issues, and has created the same kind of legal mess where who's the mother, and you have one very famous case of baby M, where the surrogate didn't want to give the baby up after she gave birth to her, and actually won the custody battle. And these are kind of legal issues that I don't think anyone really thought would come up with this technology when we were, when they were first discussing it, decades ago. You talk about the ethical problems, but there are some serious legal issues here, and there's no consensus on them. That's also the frustration. It's you're trying to find a precedent for this case, and there really, there are a few you can point to, like you said, but it's different by state. There's no there's no broad consensus on some of these things.
Well, I have to say that when you look at what is involved from the judge's point of view, it gets very hairy very fast, and I can see why the judges don't want to have to be figuring out a lot of these questions. For instance, in our case, it's rather simple in a way because it's the mother herself who wants to have the embryos implanted in her, and then she gives birth to her own children, and that's not too complicated a situation.
Right.
Even if you turn it around, though, there's a case out in California right now where it's the husband, the father, who wants to preserve the embryos, and it's the mother who does not. What happens if the court finds that the father should be allowed to have custody? What's the father going to do? He's going to have to find a surrogate of some kind.
Right.
And does that mean that the court should order that they go to the husband only if he has somebody lined up already? Or is he going to be given a certain amount of time to come up with somebody? And what happens if he doesn't? Who's going to pay the cost of that? And can the court force a mother, for instance, to actually take the embryos and bring them to gestation even though she doesn't want to? Well, that's not the way we want to argue from the pro-life movement, because if we have the mother take the embryos, then she can just go out and have an abortion. And there's no way to stop that.
Right.
The Supreme Court with Roe versus Wade and all those cases have stopped us from being able to do anything about that. So the best interest of the children are first and foremost to come alive, but how a court actually makes that happen can get really hairy really fast, and that's one of the difficulties in this whole situation.
Right.
And people jump into it, scientists, doctors, parents, without thinking these things through. And as a society, that's our tendency. We basically say we can do it, so we're going to do it unless somebody stops us. And we rationalize whether or not it's right and wrong. And
exactly.
That's what produces this mess.
Right. Well, that's what I've always said. I mean, IVF and these reproductive technologies, it's like, they came about faster than we, the general public was really able to process it. And it was kind of like, all of a sudden we can do this technology. Obviously I wasn't around when this first started. I don't know how much discussion there actually was. But it seems like, the, scientists and the medical community, they just kind of took it and ran with it, and without asking really any questions. And some people have a hard time seeing it. I know friends that are very much in favor of this technology, and all they can see is like the great things that it does. Oh, look at these families that are, that wouldn't happen otherwise. They see only these positive things that have come out of it, but there's this legal mess, and there's, all of these other things. You've got the, reproductive tourism in places where they've had to actually ban, in India, I think they banned reproductive tourism finally, where, and people it's just created a lot of problems, and, that we're finally seeing, I think some people are finally, taking note of it. Like recently with the surrogates there was 2 of them last year that came out talking about how they were being forced to abort one of the children they were carrying. And, that's another legal battle that, who has the right to tell them, is it the intended parents who are paying for these surrogates to carry their children? Do they get to force them to selectively reduce if they don't want 3 kids? They want only 2 kids instead of 3 if the woman's carrying triplets. Who gets to decide, whether she has the abortion or not? A lot of these legal issues are coming up, and I'm hoping more people are paying attention to the kind of mess that it's gotten us into, because it's not all rainbows and butterflies here that this has created. I think some people think that this is just a miracle technology. A friend of mine, she thinks it's just this great gift from God that has allowed infertile couples a chance to have babies. But then you see things like this, and it's really sad what has happened.
There are a lot of problems, and I don't want to dismiss the very deep feelings that women and also men have when they cannot, for some reason, have children, when they're infertile for whatever reason.
Right.
I think a lot of people in that situation need to check out some pro-life alternatives first before they think of IVF right away. But I don't for a minute want to shortchange the anguish that they feel. On the other hand, there's a right way and a wrong way to do about everything.
Right.
And the enormous problems this causes with IVF and the custody battles when things fall apart, and then the surrogacy, which is on a layer on top of that, that indicates that we ought to go real slow in these things.
Exactly, and we just haven't. And but I'm really grateful to Missouri Right to Life for taking this on, and I'm really hoping I'll definitely be following it and hoping that at least we'll have maybe another precedent here in the future for what to do in these kind of situations, because that's really the problem. It's.
Yeah, I think the timeline will be that after the brief is submitted by the respondent with whatever friends of the court the respondent has, it'll be about, say 90 days before the court hears the oral arguments. And in a court of appeals, the oral argument is not a courtroom scene like you see on TV and on movies. It's two lawyers making legal arguments to, in this case, a panel of 3 judges on why the trial court did or did not get it right. After the Court of Appeals makes its ruling, it could go to the Supreme Court of Missouri, the state Supreme Court, and we'd do this all over again.
Wow.
So it may be a year and a half before we get some definitive answer, but it's hard to predict what our courts will do. Our legislature has done an excellent job, and I think that the authors of the 1986 law were very far-seeing in the way that they structured it and put it together. And there isn't another law that's as comprehensive in the country that I know of. Illinois had a law that tried to do the same thing, not nearly as comprehensively, and the Illinois courts basically said, well, it applies only if there's an abortion, and too bad that abortion's covered by federal law because we can't do anything about it anyway. So they basically overruled the legislature because the legislature didn't write it as broadly as the courts wanted there. Our law is written much more broadly, and I think that if there's any place that has a chance of upholding the pro-life side in this country, it's in Missouri.
Well, good. I'm glad, and I'm even more proud to be kind of involved with Missouri Right to Life because of this. Missouri Right to Life has done a great job of actually staying on top of some of these other life issues. They're obviously doing a great job with abortion, and a lot of even other pro-life abortion-related laws around the country are modeled after some of Missouri laws. I know, but then Missouri's also been on top of the cloning issue and the embryonic stem cell research issue, and kind of holding legislators accountable for some of these things. And so I'm really glad that, even more glad to be a part of Missouri to Life because of this, and I'm just glad for them to get involved. And I am just thankful for especially all the work you've done. I'm sure this has not been a walk in the park.
I put a few hours into it, yeah. And they doubled my salary, but that, my salary's zero to begin with. Didn't do much for me, but I'm happy to do it. The work that I've done as a lawyer, I've been proudest and actually most rewarded by the work I've done for Missouri Right to Life. So I was very happy to do it, and I know that there are a lot of other good lawyers who are in the same fight. Jerry Nieders, our legislative director, contributed to the brief. The Thomas More Society people up in Chicago were very, very helpful and very good. It's been a real team effort, and it's been a joy to work with such good lawyers.
All right. Well, I wish you all the best of luck, and thank you for talking with me and my listeners and letting us know a little bit more about that.
My pleasure, Chelsea.